Hypocrisy.
Hey, what's up, guys? Welcome to Lawsplaining, the interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Damn, my fucking cable. Will you stop? Stop it! Stop it! I've got this long headphone cable so that I can move around a little bit, and it's getting under stuff. How's it going, guys? Welcome. Happy Monday. I don't know that Mondays are typically happy for most people, but I say happy Monday anyway. How are you guys doing? I hope everything's great for you. I will be joined by Joe, Good Lawgic, in just a little bit. I saw him raid the channel, which is awesome. Thank you very much, Joe, and welcome to all of his audience who happened to transfer over. No, my goodness. Whew. Okay. Well, have we got a show today? We have got something that I am not sure anybody else has or is covering. I have gotten my hands on the Blaze response to Sydney Watson, which is something, isn't it? The Blaze response to Sydney Watson. So we'll be going through that. We'll be going through that today with Joe. I don't think he's seen it. As far as I know, I'm like the only person who's seen it, but maybe someone else has. I haven't seen any other lawyers talking about it. But I also don't really check, so we'll see. Timcast? No, I don't follow Timcast, so I have no idea what would happen. I won't say that. Never mind. Yeah, so we'll be going through Sydney Watson's lawsuit, and then also in other big civil lawsuit news. This is a case we've been watching for a long time and has come to a conclusion. Chris Avellone, who is a highly regarded and well-beloved, was a highly regarded and well-beloved video game developer, mostly actually a writer on some pretty big video game titles. He was falsely accused, as seems to be the story in any of these industries. Yeah, I know he still is a genius writer. I'm saying he kind of got thrown out of the industry and over these accusations, and he has now won his lawsuit. Is the damage fully done, though? That's a good question. But he's beaten his lawsuit. We're going to look at kind of how that ends up. So that'll be fun. We'll see how that turned out. It did end by settlement, but I believe the settlement is significant, very significant. So there's that. And then, I don't know, is there anything else that has happened of note today, like in the past couple days? I mean, I'm not aware of anything. Like, there wasn't like a school shooting. I mean, because if there was like a school shooting, it would probably be pretty big news, you know, like if it was, but I don't know, maybe I haven't heard much about it. I don't know if it's probably something we should just forget about. I'm thinking, yeah, that one's probably one we just have to forget exists, and that didn't happen or anything. No, just do not look, do not pay attention. So yeah, that we'll probably talk about that in the, in the second part of the show. something like that. Woo! What a disaster. Also, yes, Chris Chan is out on bail, apparently. So that's good. Mothers beware. Hide your moms, hide your grandmoms, hide his mom. Gross. Let's see, where do I? Here we go. I really want to just open that file. There, that's what I was looking to do. Oh my gosh. So we've got that. I've got the Sydney Watson Blaze response here. We'll kick that over to Joe in just a minute. When Joe gets here, I assume he's probably out for a smoke, or Dad told me he was going to get cigarettes. Let's see. Corrections Gear says, do you think the police will release the shooter's manifesto, aka the Tranifesto? Wait, do they have one? Do they have? I know they usually have one. Will it replace Unbreaded? That's the real question. Is it enough? Is it enough to replace the Unbreaded? Hey, what's up, Drex? Drex says he'll see me next week. Sounds great, buddy. We'll see what's going on with that. This is an interesting one because it's the first it's a female shooter. Wait, so is it a woman who wanted to be a man? Or was it like a man who was wanting to be a woman? I don't even know. We'll have to look into that story a little more. Woman trying to be a man. Okay. Well, this is interesting because does that make it a female shooter, which would be, that'd be pretty rare, or does it make it a male shooter, which would run with the, I guess we'll have to see how the media covers it, right? But I have, I have no idea how that's all going to play out, if they even will. We'll see. We'll talk about it as we go. One thing, I've got beef with Crowder. Everyone should know. I've got beef with Crowder. My beef with Crowder is that since he joined Locals, it has become so damn popular that they're working on keeping things up. So I know that like some of the local stuff, the whatchamacallit, the locals, some of the local stuff is not coming through, like the notifications aren't sending out and stuff like that. But it hopefully will be improving very soon. I think it has basically everything to do with the fact that a whole bunch of people joined up for Mug Club, and it's been like things have just been wonky ever since then. So bear with me on local stuff. Sometimes it's hard to get into the chats and whatnot, but you generally can do it. But anyway, so other than that, I'm trying to think if there's anything else we definitely need to talk about. Neem Systemic sent a 3-part Rumble rant. Let me get this real quick. He says, hey, Nick, was hoping to use my first Rumble rant ever promoting myself, but I got a buddy in desperate need of some help. He's looking for law offices in Texas, and I was curious if there's a way he can get in to contact with you for advice or info on anyone who could help him down there. I should have stated he passed the bar exam in Austin recently, and he's looking to start his career, not legal advice. I know a couple people with offices in Texas. Yeah, have him send me an email, I guess, and I can talk to him, maybe get a resume from him and figure that out. We'll see. I can't promise anything, but certainly you want to go ahead and push on all the doors you can and see which one's open. Absolutely. We need to talk about why you didn't watch Top Gun Maverick last night, Law, because just about everybody's seen it. I liked that movie quite a bit. but I didn't really want to watch it on Twitch. If you guys don't know, Sunday nights around midnight Central, it's kind of flexible because Twitch is heteroflexible. On Twitch, I do movie live streams. We watch a movie through, it has to be a free movie on Amazon Prime, and it runs through the Twitch service. So it's all completely like legal, no copyright issues or anything like that. And it plays the movie, and then it puts me up in the corner like a bitch. And I sit and watch it with you and comment and laugh about the movie, kind of like Mystery Science Theater. And importantly, you can turn me off if you want. Like, you can turn the volume on me off and watch the movie yourself if you want to. But if you don't know that I do that, because I don't really talk about that too often, I do that on Sundays at around midnight Central Time, and it's a lot of fucking fun. It's a lot of fun. Oh, okay. But yeah. So anyway, let's pull up this Blaze lawsuit. Well, I guess I'll lay the foundation for the Blaze lawsuit, and then we'll pull up the response, and we're gonna get in it. We're gonna get into it. Or as Camelot would say, we'll get on it, doggone it. Here's what we got. We got this lawsuit. There was a show on oh shit, there's a couple locals chats here. Carrie Mache says, rackets, Congress is trying to shutter the internet. They say it's a ban of TikTok, but of course it's just tyranny directed at Americans. Yeah, I'm actually not in favor of Congress banning TikTok. I don't trust Congress to understand the internet enough to know what to ban. And I'm really just not a big fan of it in general. I hate them. I hate Congress. I hate the fact that such dumb people have so much power over our lives. Cassie Mayron says, you look nice in dark gray, Nick. Hey, thank you, Cassie. Thank you. All right, here we go. So lawsuit. This lawsuit is Sydney Watson, and she is suing the Blaze over a show that she was a creator on. The show is called the You Are Here podcast, and she was a co-host of this podcast, co-creative talent with Elijah Schaefer. Elijah Schaefer independently produces his own podcast called Slightly Offensive, and Sydney Watson independently produced her own YouTube channel. They were hired to co-host this show, which would talk news, current events, culture, all the stuff that all these shows all talk about, mine included, right? And it had this dynamic of having them both on, and they brought in guests. They would bring guests down to the show. I was a guest on the show twice, actually, including the very last episode of You Are Here. You Are Here, after my last appearance, unceremoniously shut down with not too many details going on, but there was some back and forth on Twitter about it. Well, what we find out now is that Sydney Watson has sued the Blaze, alleging, among other things, sexual discrimination, religious discrimination, and a failure to manage Elijah Schaefer. Because according to Sydney Watson, there can be too many dick jokes in one podcast. Which, I mean, I guess that's what she says. I don't know if that's actually true. If we can quantify the top number of available dick jokes and like apply that standard somehow, but that's what's in there. Importantly, she is not suing Elijah Schaefer. She is suing the Blaze for failing to manage Elijah Schaefer. All right. So she alleges all of this stuff. Some of the stuff she alleges can be kind of serious. You know, this idea that Elijah was booking guests onto the show that ended up being very misogynistic guests, and that she was not comfortable with the misogyny and kind of being the butt of anti-woman dialogue between the guests, maybe with Elijah involved, whatever. She wasn't comfortable with that, she claims. No. The Jack Murphy incident. So one of those people is Nick Fuentes, who she specifically names. Another person is a Jack Murphy incident in which Jack Murphy was asked a question by Sydney Watson about a cuck article that he had written back in 2015. He was asked this question via super chats that she had read. And she claims that she was forced to read these super chats, which doesn't, I mean, I'm not saying nothing. She read the super chats, and then eventually Jack Murphy went off on Sydney, saying, fuck you, heartfelt. He was very, very upset that she would read these super chats that had questions for him about this cuck article he had written. And he kind of blows up at her on the set, and then he leaves. And what was interesting was a couple days later, after some Twitter stuff happened, Sydney and Elijah returned to the show after the weekend, and they did a show together talking about how that was all fine, that everything was okay. Sydney was fine with how Elijah Schaefer reacted to Jack Murphy's reactions to her questions. That was all good, apparently. But now it's not good. And now that is Elijah's fault. He should have been a chivalrous man and stood up for her in that moment, according to her lawsuit. And there's some other stuff in there. And what she's suing for is millions of dollars in compensation. She says that being terminated effectively by the Blaze and with the ineffective management has forever tarnished her career as a serious broadcast journalist in conservative media. That has destroyed her. Now, I don't know if that's true. She currently works with the Quartering. I don't know what arrangements they have or anything like that, but she is working with the Quartering, so she is able to continue work. She also has a pretty damn successful YouTube channel. But you know, that's the allegations. And with that, let me welcome on someone else who's all allegation. What's up, Joe? How you doing, buddy?
I love the way you tell that story. It's like every time I hear you talk about this, I think to myself, I can sort of picture the last live stream I'm ever going to have is probably going to feature Nick Rekieta.
Look, if you want to end everything you've ever built, just invite me on. That's all I'm saying.
I can totally envision that. Hopefully it doesn't end up like being quoted verbatim, in a lawsuit at some point. But but the expectation is there that whatever way my show ends, it's probably going to say featuring Nick Rekieta somewhere in the title there. Yeah,
that's correct.
When I hear this story, I think to myself, she and Jack Murphy made the same mistake of not recognizing that the show they're going on and being upset when it goes in a direction that anyone should foresee this is where it's going to go. If you're Jack Murphy and you have that history with the cuck article, he should have known I'm going on with Elijah Schaefer here and you are here. Like his audience is looking for Elijah Schaefer. And
there was chatter building up around the cuck article outside of the show, from what I remember.
Yeah.
And so then, because I think it had like popped up on 4chan right before that, people had started to talk about it. So then he goes on, and of course they don't ask anything because I assume they had no idea, right? Like I assume Elijah and Sydney, if they're anything like me and probably like you, it's like unless you're looking for something, there's so much noise that you can't, like, you don't know what's going on.
I didn't even know what we were going to cover tonight. So I'm going to know what someone's going on in someone else's show. No, there's no way to know what's going on in people's
right.
thing.
Well, I have the response to the lawsuit. So that's
the answer to the complaint.
Yes. Ooh. So we're going to cover that. Ooh. And then we're going to talk about this Chris Avellone lawsuit a little bit and the resolution of it.
All right.
So, and then we can do whatever the hell else we want. I mean, I figured
we could talk about the trans agenda.
I don't know that there's anything to talk about involving trans people that's major in the news right now. I haven't heard of anything. Have you? Can you think of one thing lately that involves trans stuff that's been in the news? Like, I don't know, in the past, even week?
I guess if you're a woman and you get involved in a mass shooting, that's like sort of like that's almost like your bar mitzvah. Like today you
This
are
is
a man.
man's world.
Today you become a man.
We'll be we can talk about that probably in the latter half of the show. I think might be the safest bet on that one.
Yeah.
But yeah, we'll do that.
Is it too soon to talk about that? That's why I want to know. The only reason I brought it up is because I was seeing that the knee-jerk reaction was ban guns. I can't believe we have all these shootings. This is all on the right, and I'm like, no, this is not on the right. This is exclusively on the left. There's no one to blame except for the left for this and the woke culture. Let's talk about it later. Let's do it.
Yeah, I figure we'll just talk about it on
Rumble.
Yeah, on Rumble.
That's a Rumble conversation.
Yes. Yeah, we'll have to do that at some point. But for now, here we go. You're right in time. You're right on time. I've got this lawsuit pulled up, just ready for us to rip it apart, Joe.
Nice.
Okay, so
who's their counsel
for Blaze?
Yeah, I know Schlechter. Kurt Schlechter is the
Celeste Yeager
from. There's no famous firm. It's just Celeste Yeager.
Littler Mendelsohn.
Huh.
Are you familiar?
No.
No.
I heard Kurt Schlichter. I thought maybe I would have heard the other side also.
And Courtney Jackson is the other, both from the Texas bar.
Mm-hmm.
The Blaze. And I think, do you think it's, we also have Jordan Cowman from Greenberg Traug.
That's Greenberg Traug is a big firm in New York.
Okay.
That's a multi-state firm. That's a bigger firm.
Gotcha. So I don't know if it's an accident that they put two women on this case.
Probably not. No.
I love when they do a table of contents. I really do. I'm a big fan of them.
This isn't an answer, or this is? Do they move to dismiss? Is this a motion to dismiss?
This is civil action. Defendant's brief in support of its motion to dismiss.
Oh, it's not an answer. It is a motion.
Or in the alternative to state proceedings and compel arbitration. Which there's a big spoiler on this. Yeah, it's not the answer. That's true. That's true. Yeah. But it does have some. It has some previews for an answer if one is required. We'll say.
Okay.
Okay, so Blaze Media moves the court for an order dismissing this action and compelling arbitration of plaintiff Sydney Watson's claims, or alternatively staying the action pending resolution of the arbitration in accordance with the arbitration agreement between the parties, and respectfully shows the court the following. So what do they think? Joe, let's get this out of the way. Why do they think that they're going to be able to avoid the arbitration agreement in this employment contract?
Perhaps they figured it's Title IX and that it's something that can only be handled by a federal court. That might be what Kurt Schlichter was thinking when he filed it in court. Normally, it would obviously they had an employment agreement.
Yeah,
and what Nick what you're getting
a contractor agreement according to the Blaze, right? The Blaze we'll see this. They're adamant this is not an employee of any kind.
All right. Okay. Yeah. So they have a contractor agreement, and that if there's any issues arising from it, I'm sure that there's a very sturdy. We'll probably have they'll probably track the language. They'll probably just copy and paste it from the agreement, the language that says that arbitration is binding. Maybe Kurt Schlichter figures that because it's a federal cause of action under Title IX that circumvents it and it came to federal court.
Yeah, I mean, I guess that's probably going to be the argument. I don't know if it's going to be the best argument. I don't know if that's going to prevail. Question. I mean, is this Title IX? Like, does this even count?
This seems 7?
This seems really weak on the to go after, if they're going to go after Title IX. But yeah, because Title IX, isn't that in schools?
I thought Title IX was discrimination. Was there
that's Title VII is the Civil Rights Act.
Oh, okay. I'm a little tired. I apologize.
No, that's fine. I just didn't know because I almost feel like they might mention Title IX in here too. We'll get there. We'll find out. So plaintiff entered into a talent services agreement with Blaze to provide co-hosting and production services for an episodic audio video series consisting of daily news and commentary for Blaze as an independent contractor. Bam. This is what they really want, right? Like they want. if they can keep this as a contractor, then Title VII is not going to be a strong claim at all. On February 8th, plaintiff filed the present lawsuit against the Blaze, alleging claims for sex and religious discrimination in violation of Title VII of the Civil Rights Act 1964, as amended, and the Texas Commission on Human Rights Act. Wrongful constructive termination in violation of the Texas Commission on Human Rights Act, and retaliation in violation of the Texas Commission on Human Rights Act. Not only do plaintiffs' own statements, emails, and text messages reveal that her claims are untrue. Plaintiff, 1, was not employed by Blaze and instead worked for Blaze as an independent contracting capacity, and 2, entered into a valid and binding arbitration agreement with Blaze that required all disputes arising out of the TSA, which created and defined her working relationship with Blaze, to be resolved through mutually binding arbitration pursuant to the Federal Arbitration Act. The court should therefore dismiss the action, compel arbitration, or alternatively stay this action pending resolution of the arbitration. Let's briefly talk arbitration, right? So arbitration is a process that is an alternative resolution or an alternative dispute resolution method that is used, where basically it's a private court. You hire a referee, and each person brings their representatives, which can be lawyers or they can be, I don't think you have to have legal counsel necessarily at an arbitration. You can just hire someone to go arbitrate for you.
Yes. Although frequently the arbitration clause will specify which arbitrator they're going to go to in the event of a dispute.
Right.
But this is arbitration in general is something that had been frowned on by the court system for a very long time in the early part of American history, because they felt that it was that what they were doing was so elite that to try and allow some layperson to try and figure out the law would just be and that's an abortion, and that's terrible injustice to the judicial system. And then they realized, wait a second, we can just trash a lot of these cases and clear off our dockets. So I think it was in the 1940s that they passed that they had the Arbitration Act, and then shortly thereafter there was a case called Swan, which ended up basically saying, yeah, if there's an arbitration clause, as long as there's no fraud in the inducement and it's been signed off on, yeah, we're gonna kick it out. And it became a thing. They were just kicking out every case to arbitration.
Yeah, you can contract away your ability to sue by agreeing to binding arbitration. Now, you can always try and overcome your contracting of that. Say it was done under duress, is not an even exchange, not a valid contract. There's all sorts of ways you can try and do it. But if the contract is facially valid, you're going to be in arbitration unless you can defeat that. Like, you have to overcome that contract. If you agree to it, it's there. And if you don't want that, then you need to line that out and try and negotiate it away. But companies like this, it's way faster than court. It's not public. It's generally much cheaper if you have individual, like, this is what it was made for, these types of disputes. The best though is these companies that have the binding arbitration agreements on customers, and then they also have no class action agreements. And so they suddenly are fighting like 700 arbitrations, and it costs them a fortune. That's funny to me. I think all companies that have that should get burned by it. But
but the reality is that most people end up not pressing those claims. That's why they do that. They figure instead of them fighting off a claim, which in the aggregate, because you have to realize in a class action suit, so everyone might have a claim for $20, and there's 100,000 people or theoretically 100 million people, and they feel like, okay, we're going to have like less than a half of 1%, which will actually press their claims if they have to go through the arbitration process and shell out money on their own. Yeah,
they'll have to pay like $250 a piece, and if your claim is $20 to $100, you're probably not going to do it. However, if people can create some sort of fund to fund those arbitrations and motivate people, and that's what we're starting to see in stuff like people going after Patreon and stuff like that. It's like, well, wait, if it's in a creator's interest to go after these things because they mess with the contracts of their people, and there are people willing to fund the individual payments of $250 a piece, even if the creator, if he's going to put up 25 grand and fund 100 of these things, I mean, that could be a very smart business investment, because 100 arbitrations is going to cost the company at jump about $300,000.
Yeah.
And it could get into the millions of dollars as things get moving along.
Well, have you ever handled an arbitration?
No, I haven't had to.
They make the defendant bear some of the costs for the arbitrator also. You split the costs.
Yeah, the thing that the big company like Jams does with larger companies that do it, like Patreon had this. They had the Jams expedited arbitration, and what happens in that is it's $250 for the consumer. When it's a consumer versus a company, the rule is $250 for the consumer, and then all of the rest of the initial arbitration fee goes to the company. Well, the initial arbitration fee is like $3,000, so it's $250 for them, $2,750 for the company. But then there are extra. California basically made it so that if you lose the arbitration as a company, you have to pay all of it, No, you have to pay all of it to keep going. Like, it's crazy. The ongoing cost stacks up. And this is what happened with Owen Benjamin versus Patreon, is that they had like 100 or 200 arbitrations going on, and Patreon was out like $5 million before anything even happened, because they're sitting there trying to get them all individually dismissed. But that's an hour of attorney time for every single one. And they have to pay, they fucked up and had to pay attorney's fees for the defendants as well early on because they were not complying with their own arbitration. It was a mess. So
yeah, I handled one arbitration. It's very weird. The hearing was done in an attorney conference room.
Yeah,
it's a very, and everything. The whole thing it's a very unsettling type of thing, but it is cheaper. So.
Yeah, and it can be a lot faster. And most importantly, the biggest thing for companies is it's not public. You can't see all the dirt. You don't get the discovery. You don't get the motion practice being posted in public. Hayden75 says, the company I contract to that has employees makes everyone sign an arbitration clause where they get to choose the arbiter. They've got like 45 lawyers with their own floor on a building. Scary stuff, to be honest.
Yeah.
By
the way, with this whole arbitration thing, the reason they would want to have this case stayed, because in the language here, you might have noticed Nick reading there that you should either get rid of this case or stay the case. The reason that it would be stayed, I imagine, is they're saying we're definitely going to arbitration, but if the plaintiff wins in arbitration, she might need to confirm the award. And so she wants the award confirmed so she can come back here and use this index number and this filing and enable her to confirm it through this case. Or I guess if the arbitrator, for one reason or another, says we're not taking it, that's the reason. Because I was wondering, like, why, if the application is being granted and we're going to say that this was good arbitration, well, why would you stay this action? And that's basically the most logical thing to me, I guess, is that they figure that the court might want to leave it open, just that Sydney Watson, if she wins an arbitration, because after you win an arbitration, that's not a legal award that you can actually go execute on. You need to have the court stamp off on it, and they pretty much rubber stamp it. It's a pretty quick proceeding when you go back to court, and unless there's fraud, they're going to stamp off on it. And that's why you would leave, but you need to start a new action. So I guess in theory, that's why they would have this stay here. I just got very lawyerly on you, so I'll let you go back.
No, I love it.
Okay.
That's what I want to, we got to have some education in here too. Let people know about this process in case they don't.
Mm-hmm.
All right. So on, here's this. As discussed in section 3.e, the Federal Arbitration Act allows for dismissal of the action to the extent necessary. Blaze also brings this motion under Federal Rule of Civil Procedure 12B1 and or 12B6. These are just motions to dismiss. Any 12B motion is a motion to dismiss under different sections. 12B6 is the most common. It's failure to state a claim upon which the court can actually create a resolution. So they're going to say that based on the facts that we have, Sydney Watson's claims all fail automatically as a matter of law. There's no plausible way for her to win. Now, that's what they're going to claim. The judge will have to decide on that. So on May 1st, plaintiff and Blaze entered into the TSA, which governed the terms and the conditions of her independent contracting relationship with Blaze to perform co-hosting production services for an episodic audio-visual series consisting of daily news and commentary for the Blaze in exchange for payment of money from the Blaze. And that's from the declaration of Tyler Carden, the Carden Declaration filed herewith as Exhibit 1. I don't know if I have that, but I think I can go grab it if necessary. The TSA contained the following arbitration provisions. So you're right. They just cut and paste it. Long story short, governed by and construed in accordance with the laws of the state of Texas, parties agreed any dispute arising between them regarding any matter related to or arising out of this agreement shall be resolved by binding confidential arbitration in Dallas, Texas, by a single arbitrator from JAMS, who must be a retired judge, having served on any federal court located in Texas or the Dallas Superior Court or a higher court in the state of Texas. The rules and procedures for JAMS. So that's the thing that's important here. You're muted.
You know why they say a retired judge? Because any adult can be an arbitrator. So they're like, we don't want you to start giving us a pool of people to select from that's going to be some carpenter or some bus driver, and it's like, pick one of these three guys. It has to be someone who is a retired judge. This way they feel like they can have someone who has some sort of knowledge about the law.
Yeah, because that's an interesting thing that so people will retire from a company that they've worked at in an industry for a long time, and then they will become an arbitrator, and the company will want to hire that arbitrator because they have industry experience and expertise.
Mm-hmm.
And they might have some sort of relationship with it, but that, industry experience and expertise can also favor, for example, a company or a worker, depending on the thing, whereas they won't be necessarily looking at legal aspects in the same way. And so they're wanting a person with experience adjudicating under the laws of Texas and the laws of the federal government, not someone who's going to come in and give their opinion on who's right based on, some workers' rights issue or something.
And you could understand that sometimes that could play in as an advantage in arbitration. For example, if there's a dispute as to whether plumbing was done correctly or incorrectly, you really might want to have a top plumber sitting there as the arbitrator, and it's because he, I guess, or she might have knowledge as to like what proper plumbing techniques that should have been used in that circumstance, more so than somebody who sat on a court bench for 30 years. So
exactly. And they probably do. They're probably right, because judges don't know anything special other than the law.
Mm-hmm.
They may have some experience with stuff, but oftentimes their experience comes from people who are lying to them. Yeah. That's one thing to remember. There's two sides to all of these stories, and experts stretch the truth. Okay, so here we go. The rules and procedures for JAMS, including JAMS emergency relief procedures, shall govern the proceedings, including the selection of the arbitrator. Parties each hereby waive any claim that Dallas, Texas is an inconvenient forum, or that either personal or subject matter jurisdiction is lacking in Dallas, Texas. Without limiting the generality of the foregoing, the parties each agree that all questions as to whether or not an issue constitutes a dispute subject to arbitration under the section shall be resolved by arbitration in accordance with the section. So here's another way, another reason that they may want to stay the proceedings is because the arbitrator may determine that this is not arbitratable.
Mm-hmm.
So in arbitrable. Okay. So it's not arbitrable. So in that case, they have a stayed proceeding. The arbitrator goes, actually, this isn't for us. This belongs to courts. They kick it back out to the courts. Now they resume the action. So there's another one.
No, good point.
Arbitrators shall have the power to impose any sanctions against any party permitted by Texas law. The filing and prosecution by any party in any court of an action alleging an arbitrable dispute is in breach of this agreement, and the non-breaching party shall be entitled to recover damages for such breach through an arbitration pursuant to this paragraph. So this is a risk for Sydney, because if this is determined to be arbitrable, then Sydney is liable for any of the costs associated with defending this quote unquote improper lawsuit, as it would be determined at that point. So legal fees associated with this, which, I mean, very quickly can reach into the tens of thousands of dollars to hundreds of thousands of dollars, depending on how this goes.
It's Greenberg Trowig. I'll tell you right now, it's already $25,000.
Yeah. It's going to be. They're going to have to research all the claims. They're going to have to watch all of the video that's alleged to be involved in this. Trust me, it gets very expensive very quickly when you're talking about an online personality suing over what's done on a show.
Yep.
Not that I have any special knowledge of that. Hayden75 says, to clarify, the company I contract to makes every contractor and employee sign a contract where the company chooses who the arbitrator is. Kind of sussy. They pay well, though. I'll probably get effed. I'm a bit of a contrarian. It's not actually that suspect. It's very common these days, especially. I mean, if you're a large company hiring a bunch of independent contractors, you want arbitration that you want them to agree to arbitrate where your home base is and stuff like that. Otherwise, you'll be all over the fucking country doing these things. You don't want to do that. So here we go. The occurrence of such arbitration proceedings shall be maintained as confidential information of each of the parties. Arbitrators shall render a single written decision reached. Any award issued as a result of such arbitration shall be binding, and a judgment rendered thereon may many be entered in any court having jurisdiction thereof. So we got a typo here.
I'm sure that's been copy and pasted dozens of times with that typo. You know, no one's looked at this paragraph in ages. And
but they mean may be entered in any court. So if they get a judgment, they would, like Joe said earlier, they would drop it in this case. They'd move for enforcement, and then they'd call Joe to start collecting. Plaintiff electronically signed the TSA on
By
May
the way,
1st.
if you do, please do call me for that one.
Despite plaintiff's express agreement to arbitrate all disputes arising out of the TSA with Blaze, plaintiff filed the present lawsuit alleging sex and religious discrimination, wrongful constructive termination, and retaliation. Specifically, plaintiff alleges that her former co-host Elijah Schaefer subjected her to misogynistic, anti-Semitic, harassing, and disrespectful behavior, and that she complained to Blaze's management to no avail. Now, are you, Joe, frustrated that she is alleging anti-Semitism?
That's why I was exhaling. Go on.
Because she's not a Jew, as far as I know.
Even if she is like DNA Jewish, she's a gyno.
A gyno?
A gyno, like Jews in name only. She's a gyno.
Oh, my brain was going in 50 different directions and not that one.
I didn't say gyno. I said gyno, for crying out loud.
Gyno? What is a gyno?
If she is Jewish, it's like, she doesn't care anything about what Judaism says or does. She's going to do whatever the heck her own personal moral code tells her is correct. And it's like just because you come from a certain people, it's so stupid.
I don't think she's even like Israeli though. Like I've never heard anything about her being ethnically Jewish.
I'm gonna tell you something. In Hebrew, there's no W, so it wasn't what it was. Vatzin, if anything. There's no this. It's so ridiculous. It's so ridiculous, and it's so offensive. It really is. I mean, if you're a black person, just imagine someone who's like, let's say, 120, 196 black, and looks as white as I do, complaining about like racism. You're like, just shut up.
I'm tired of being called the N-word, Joe.
No, I don't blame you. I don't.
Everywhere I go, the police beat me. They plant guns on me. No,
no, it's really just like, just stop whining. It's like I'm sure I wouldn't have whined about any of the jokes that they said there. And I practice this thing on a day-by-day basis. And yeah.
Well, it was such a weird thing to see in the lawsuit. Like, why are you throwing why they're throwing anti-Semitism in? This is a nasty, pervasive problem in the civil litigation world, in my opinion, is that they're constantly trying to poison the fact finder with irrelevance.
Mm-hmm.
Like, they're trying to poison Blaze and Elijah Schaefer because they rolled the dice and said maybe this judge will be Jewish, and so it's honest. It's
not just that; it's poisoned the public before it even gets to trial, so that your jury pool comes in there already tilted against that. That's what we saw in the Murdoch trial. That the more you can poison the public, the more likely it is that you're going to be selecting from a jury pool which is out for blood against this person because of things that are completely extraneous to the actual lawsuits or any offense that the person or injury that the person actually sustained.
Yeah, no, it's crazy. In not to bring this back to me, but everything comes back to me. In my own lawsuit, that's what's going on. I mean, the other attorney is trying desperately to poison the well with stuff that he knows has nothing to do with the alleged defamation. He knows has nothing to do with intentional infliction of emotional distress, and he knows is slanted. Like the title of an article that says, "I built an online hate factory." He's trying to, which I don't even know what that is. Like, I wish I built an online hate factory. That sounds awesome.
Yeah, it really does. It really does.
Like some dope named Kevin Featherly at the Minnesota Lawyer publication wrote this stupid article that I was somehow creating a factory of hate, but this is years ago while I was covering the Vic Mignogna case.
What's
And
your
like,
raw material in a hate factory? I'm just trying to figure out what you're processing there. Like,
I
where
don't know.
do you
I think it's
get that raw
memes.
material? Is it? It's memes?
Yeah, it's memes. We have to source them from 4chan.
Maybe it's Slate. Maybe it's Slate is like is like your raw
What's the-
material. You
what's the
take the
hate
raw material of
factory?
Slate. This is what it is. You basically take the raw material of Slate, bring it into your house, mix up like a few shots of whiskey, just jumble that
Good
around
idea.
there, and it just a whole thing ends up becoming into like this whole morass of hate, and you stir up the
A
masses.
morass of hate. More
Yes.
ass, not less ass. It was just it's crazy. And so it's like this dope Kevin. What's up, Kevin? I hope you watch my show by now, you
That's the
feckless little
lawyer?
weirdo. He's the writer for Minnesota Lawyer. He was like a pseudo journalist. I don't know what they even are. It's one of those periodicals that goes to all the law firms.
Wait,
right?
your case is being covered in local Minnesota news?
No, not yet. No,
Oh.
this was when I covered Vic's case.
Oh.
This guy wrote an article that I was creating an online hate factory using my platform since I'm a Minnesota lawyer. And like,
like back then you had like 30,000 subs. It's like
the deep hate of me saying, please never contact these people. Don't do anything to them. Don't dox them. Don't go to their house. Don't call them. If you see them at a convention, just smile and either buy their stuff or don't if you don't want to. Like that was the hate I was spreading, Joe.
Obviously.
It was so vile.
Obviously.
Like,
yeah,
Jesus Christ. But see, that title, the headline was all that was necessary,
the
right?
Factory of hate.
And so now this dork who's suing me and his lawyer, like, we'll poison the well. He's used to creating online hate factories. I'm like, God, if I could just harness online hatred into a factory, I can make great things. But you can't do it.
It's much
Unix,
harder than it looks.
Unix EDU says no's. Thank you. All right, back to this. So harassing and disrespectful behavior that she complained to Blaze's management to no avail. Plaintiff further alleges that Blaze constructively terminated her in the spring of 2022, or alternatively actively terminated her in or around July 2022 after she complained, through counsel's demand letter about Mr. Schaefer's conduct. Plaintiff's outrageous claims are made in an attempt to circumvent her status as an independent contractor with an agreement to arbitrate and create a circus or media frenzy by filing a lawsuit in a public forum and directly contradicting her own description of the events she now attempts to paint as discriminatory, harassing, and retaliatory to this court. And this is what I was saying when we first covered this. The actions of Sydney Watson at the time, and the words of Sydney at the time, run counter to her narrative about the suit and the circumstances. And that, look, whatever the truth is between those two things, because it's always on a spectrum. Oh, she was playing tough for the public, for the show, blah, 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 blah. And now she's playing extra victim because she's got a lawsuit. So it's somewhere in the middle. It doesn't matter.
Bill Burr nailed this when he was saying, like, everyone knows no means no. No, it doesn't. No, it doesn't. Sometimes it's no, stop it. Stop it. No,
that's true.
You're so bad. Oh, you're so bad. Oh, stop it. So then when they read the transcript, it's no, stop it. You're so bad. Stop it. And you're sitting there thinking, like, it didn't sound like that.
Yeah.
And that's what it is with Sydney Watson also. It's like, yeah, maybe like if we read through transcripts of the conversations there, but the whole time she certainly looked like she was a willing participant in all of the humor that was being purveyed on that show.
Right. And her comments about like the Jack Murphy and Nick Fuentes, which we're going to get to on this in a little bit. I mean, they're damning for her claims. Okay, so here we go. For example, plaintiff complains in her complaint that the choice of guests compounded her growing discomfort with the show. She alleges on December 3rd, notorious bigot Nick Fuentes appeared on You Are Here. Yet in a text exchange on December 4th with Tyler Carden referencing the Fuentes guest appearance, plaintiff agreed with having Mr. Fuentes on the show, although she now complains it was harassment. She further replied that usually when she thinks a proposed guest is a horrible idea, she says no right out of the gate, and they do not get booked. But she, quote, let the Nick thing slide and was glad she did to an extent, and that she does not mind woman haters. Ooh, not not going to help those claims.
Nope.
She further defended her decision not to veto Fuentes' appearance in a text message to Mr. Cardin. Like I said, shoot down bad ideas with good ideas. Half the issue is that we try to hide undesirable views rather than pulling them out into the light and seeing them for what they are. And I remember, like, I didn't watch the full episode, but I saw clips of that thing and I saw the comments, and most people were laughing that the women on the You Are Here show that day, Sydney and I think someone else is there, basically just shit on Fuentes for being a virgin or whatever. Like, not actually a virgin, but just shit on him for being so weird about women. Like, they just, and he didn't come across well in that encounter. Like, from what I remember reading, maybe I'm wrong on that, but they came across as like, this guy's just a complete fucking weirdo.
Mm.
So
I didn't
it's
see
like,
the episodes, so I don't know. But
yeah. So she furthered, let's see, here we go. Plaintiff told Mr. Cardin that he could trust that she was making hardcore vetoes whenever she felt a proposed guest was a bad fit. Mr. Cardin replied to plaintiff via text message on December 4th, stating that Mr. Cardin spoke to Mr. Schaefer and asked the plaintiff to please give Mr. Cardin a heads up if plaintiff's instincts are ever telling plaintiff the guest is a bad fit. So she has this guy who's like, yeah, if there's ever a guest is a bad fit, tell me, I'll tell Schaefer, no big deal, we'll work it out. Plaintiff never did so. Further, prior to Mr. Fuentes appearing on the show, plaintiff answered a viewer question during the show in regards to Mr. Fuentes appearing. In the September 15th episode of the show, plaintiff said, I just disagree with a bunch of his stances, but the plaintiff was not anti-platforming people, and that plaintiff does not care because you interrogate ideas, and if it's a bad idea, use a better idea to beat it. I don't understand. I'm fine with that.
whoops.
So again, you don't get to be fine and then come back not fine. Like, that's going to be a big problem for her.
Now, I will point out that the arguments they're making here are really relevant to the whole arbitration clause part, but they're sort of planting the seed in the mind of the judge in case, for one reason or another, somehow does not make it to arbitration. Just understand how silly her claims are. So they're going on for pages and pages here, far more than they need to, because they basically are saying, let's make sure the judge understands how bad the plaintiff's case is, and encourage him to shaft this out. And if he ever is forced to take it, to recognize that Sydney Watson has no claim.
Yes, and that's going to be the big thing. Like, look, judge, kick this to arbitration. They'll deal with it there. And here's a preview of what they're going to deal with. And you know how they're going to deal with it. If you have to deal with this, we're going to appeal on the arbitration thing. It's going to be a big mess. And it's going to force the issue. Or you can just realize that this belongs in arbitration. And if the arbitrator says no, then we're back in your court and you don't have to do anything. Like, you're fine. Also, plaintiff complains about Jack Murphy appearing on You Are Here on December 17th, yet it was plaintiff's idea to book Mr. Murphy as a guest, and she personally added his name and contact information to a list of guests to book for the producer to arrange for Mr. Murphy to come on the show. After Mr. Murphy's appearance, plaintiff created an entire merchandise line based on the episode featuring his appearance. During the episode, Mr. Murphy said to plaintiff, "Fuck you, heartfelt." Plaintiff then created designs for sweatshirts, hoodies, t-shirts, and coffee mugs branded heartfelt, which are currently offered for sale on plaintiff's website.
Man.
I mean, that's a solid point.
Yeah.
How are you harmed?
She was fine grifting on it, but it really hurt her feels.
Mm-hmm. And very traumatized is how any fact finder has to look at this and go, it doesn't seem like trauma and harassment to such an egregious level that you
after he said that to you?
Yeah.
Did you pay for that counseling with the tens of thousands of dollars on t-shirts and mugs you sold with the whole FU heartfelt?
In addition to plaintiff alleging she had growing discomfort with the show, plaintiff also alleges that she continuously complained of alleged misconduct from December 2021 to August 2022 and was ignored. However, plaintiff's own text messages and communications with Blaze Management, including Mr. Cardin, do not align with these allegations. For example, on September 11th, #neverforget, plaintiff texted Mr. Cardin that she, quote, really wants some leftists on or people who we don't agree with. The same, agree stuff is a bit ZZ. So she wants conflict. There's the first one. We want some conflict. On January 3rd, in a signal chat between plaintiff, Mr. Schaefer, and Mr. Cardin, plaintiff stated that she, quote, is getting great feedback. On January 18th, Mr. Carden asked via text message if plaintiff is doing okay, and plaintiff responded, I am actually doing great. January 18th, plaintiff claimed she has some great ideas for the show. May 14th, plaintiff tweeted via Twitter, Blaze and I are still connected and hopefully can produce something awesome. When plaintiff informed Mr. Carden she no longer wanted to co-host You Are Here, this is her this is a big problem for her as well. Because remember, she's saying that she was terminated from the Blaze, but she doesn't have a Blaze employment contract according to the Blaze. Like their position is that this is a talent services agreement expressly for the production of the You Are Here podcast. That is her thing. If you don't want to co-host it, you're in breach at that point. Like you either have your exit clause or you're in breach of the contract. And if you're
be fair. I think a lot of the rich and powerful corporations have learned the proper nomenclature to use to position themselves where they have such unbelievable leverage over the contracting parties who come in the door. And we see it a lot with real estate, where it's like you're no longer like it's not even a rental agreement, but it's a licensing agreement to use space. And this way, when they call a licensing agreement, all of the rent laws that normally apply, they try and strip you of those rent protections. And in referring to her as an independent contractor, now there are lines of delineation as to when someone qualifies, and there is voluminous case law to try and determine how should the court assess whether someone should be qualified as an employee versus an independent contractor.
Right. And it's fact and case specific. It's like fair use. There is no, you are now an employee, you are now an independent contractor. It's a fact question. There's like 20 factors that they can consider. Sorry, I didn't mean to interrupt. But
no. It's your show. And if you don't interrupt me, it'll become my show. So
I'll just distract you like this.
Oh, you know that's what always gets me.
every time.
So but my point is that is an abuse that the powerful employ and use that trick regularly to try and give themselves a lot more control and a lot more protection in case things go wonky. So
right. So a key difference, one of the main aggregations of factors that they're considering for contractor versus employee is how much overall control does the company have over the person. So for an employee, like you control their schedule, their time on, like when they show up, if they wear a uniform, where they work, you can send them to other locations. You can demand that they do stuff remotely. You can send them on trips. Like all of these things are within employment agreements. Contractors have a lot more flexibility. They're directing their own schedule. They're providing a service. They're almost like a business that you call up to help you with something. So sure, you can get them to agree to certain things. Like, yeah, maybe they're gonna do this show. Like the You Are Here podcast, technically, I think they had to air a show at a specific time. It didn't necessarily have to be live. They chose to do it live. They could probably have pre-recorded it, or they had some flexibility on the scheduling, anything like that, where they have more and more control over the conditions of their work leans towards independent contractor. And then anywhere where the Blaze had control over what they did leads towards Blaze. They didn't have uniforms, for example. But if Blaze had a language policy, which they didn't seem to on You Are Here, like you could kind of go off. But if Blaze had a language policy, that would go towards it. Blaze clearly didn't have a no drinking policy on there. They didn't have a language policy. And all in the contract, it was expressly stated that the talent together would write, direct, and perform the show. And so that gives them a ton of flexibility. And so even if we say, well, but Blaze demanded that they broadcast at this time every weekday for this many weeks, you go, yeah, but look at all of the other flexibility they had. They could create the show entirely the way they wanted. And all Blaze had was some veto power over guests, for example, that they never exercised. Can we call that an employment agreement, or does that seem like a contractor? And that's the question the court has to wrestle with in these things.
And I agree that ultimately, if assuming that the contract, and I'm positive it does based on the wording here, assuming it refers to them as an independent contractor, not as an employee, I do think that there's enough factors here favoring independent contractor that whoever the finder of fact is, whether it's the court or an arbitrator, there's so much flexibility in how the work is produced, who's going to be there, the nature of the show. I mean, the ability to inject variety is part of what they're looking for. They probably didn't want to be hands-on as long as they knew it wasn't going to, they might have said things like no nudity, but beyond that, basically.
Yeah. But, and they can also rely, they can let that fall on YouTube's terms of service.
Right.
But look, they're producing this show for YouTube. YouTube has terms of service. They have to be compliant with that. And that's going to fall in the independent contractor thing. And another thing you brought up that I didn't mention that we should mention is that one big factor that courts have weighed in this question is what is the understanding of the parties themselves? And if both parties, like you said, if it's clearly stated in their talent services agreement that they're independent contractors, if both parties understand an independent contractor relationship, then outside of some massive sort of shifts of power that happen, the court's going to presume that these are both sophisticated parties, may have both been represented parties when they're signing this thing, and that their understanding is independent contractor, and they're going to lean that way. But again, if Blaze starts exercising control and says, yeah, you want to keep your contract, you got to do it this way, that can still push it back. But they're going to defer to the common understanding most often.
Does Title VII have any application, to your knowledge, in an independent contractor relationship?
I could pull it up. I don't think so.
Because that's why they're making such a big deal about this. They figure they can walk away from having to go down the whole Megillah, and they could probably get just a summary judgment saying there's no Title VII application here because she's clearly an independent contractor, and all these claims go by the wayside. And I think that they're hoping. Then that's why from out of the gate, before they even bring up the arbitration clause, they bring up this independent contractor thing, because that has the capacity to just torture her entire case.
From brief look, I mean, the simple answer is no. Title VII doesn't apply to independent contractors. Now that's a simple answer. The question is, are they independent contractors? Is there some part of Title VII that can bust in? Probably not. But one of the other claims, even if Title VII does apply, when you're talking about TV and radio talent, you have a massive problem proving discrimination, because the number of people that you're hiring are very small and very specialized to their voice. Like, no one's going to say that the Blaze hired Sydney Watson because she wasn't a man. Like, they're going to hire Sydney Watson because they've seen her commentary, her work, and they want that product that she provides. And there's not like a group of comparable Sydney Watsons, hypothetically. Like, there's only one, right? If someone wanted to hire good Lawgic, they can't just go, well, we need a lawyer to hire, and then they go and hire like Law and Lumber. You're not getting good Lawgic. You're getting a completely different show, different vibe, different personality, different perspective, different commentary. You're just not getting what you want. So you can't say, Joe's like, well, they're discriminating. Like, if, let's say the Blaze hired me and not Joe, he can't be like, well, they're discriminating, anti-Jewish. That's why they hired Nick. It's like, well, no, there's not that many. Now, if they were hiring in their general law firm things, and two lawyers come up and, we'll say several lawyers come up for hire, and they just never hire a Jewish one ever, you can start to build this theory that, okay, they're clearly avoiding.
That's a cumulative effect, not on an individual basis. Yeah.
And yeah, you're going to have real trouble getting individual basis on anything with a talent. Even if a network hired only white men to be their on-screen talent, it would be really hard to suggest that they have to hire anything else, because if those people are if they can make any reasonable claim that these people have a specific voice that they want on there, even literally their voice, then they're going to win on the discrimination claims. And this is why you can't force movies to hire black actors. Right. You can't. They've tried this.
We've seen in the NFL that that because of legal, I think it was because of legal action, that the NFL agreed to the Players Association that they were going to interview black coaches Like you have to talk to at least one black coach. So, and that was because they looked at the cumulative effect and they said, how is it that there's all these players who end up graduating from playing to coaching, and so few of them are black when there are so many black players? But there was such a gross disparity there that it was visible.
Right.
So,
yeah, and I mean, you can get there. It's just it gets really hard when the talent is so limited in these things. And I strain credulity calling either of us talent, because we're just like people who we're just people who got like to do this. But if if Daily Wire approaches you, then you know, like you're in talent mode. Or if Breitbart is like, Joe, we love you, we want you to start writing up articles for us.
Rumble considers you talent.
Yeah, I guess so.
There you go.
Look, no one ever said they had good judgment. Oh, damn it. I got my Rumble 100K subscriber award and I forgot to bring it down.
Congratulations.
Thank you. Thank you. It's very cool. I'll bring it down tomorrow. Drex's unused Baldo says, hey, Mr. Nose, I sent you a Twitter DM and I'm hoping you can shill my gifts and go. Character limits on Rumble, so I'll put the rest over there. Ignore the prior one from last year. We all gave up on it. Okay. I guess. Let me see. Let's see. I don't know. Is this it? Oh, here it is. Oh my gosh. Let's see. Long, detailed version, the description of the gifts and go if you wanted to skim it prior to shilling. May not be as serious as a lot of ones people had, blah, 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 blah. 100% P&T disabled vet with a bad back and messed up head, not having a vehicle to make it to any of my usual weekly therapy appointments. I'm getting into a bad spot. And funding a lawsuit is rough, especially when you live on a fixed income. Any help is appreciated. So here we go. I'll pull this up real quick, or I'll share this one in the chat. It's called Civil Lawsuits Suck, which is true.
Mm-hmm.
I'll share this one in the chat for anyone who wants to check it out. I did just see that my boy Camelot has rated us. What's up, Camelot? Camelcast viewers. Camelot was on with a couple pretty ladies today. Good work, buddy. Doing a great show. And everybody should check out Camelcast. Absolutely. And I can't wait for the next time I show up on there. So I did put the gifts and go in all three chats. If you want to go check it out, please do. Anton Shutter says, hey, Rackets, I'm 25 and don't drink, but want to have one with my father. What whiskey do you recommend within $100 range? I can do over that if there's a good one. Thanks. Well, there's tons of good ones, but dude, I'm going to give you a great one right at $100, depending on where you are. It's called Angel's Envy Finished Rye. If you're not a drinker, if you're not like used to whiskey, this one will be good anyways. It's smooth. It's pretty sweet. It's got a great flavor, great aftertaste. It's not going to leave you gagging. And your dad's going to like it. If your dad likes whiskey, he's almost guaranteed to like it. I've met one person who does not like the Angel's Envy Finished Rye. That one person, and I've had hundreds of people talk to me about it because I recommend it all the time. It's a great $100 whiskey.
I've never heard you mention that ever. Like, not even
Are you
once.
kidding me?
No. I was going to bust out a new one and recommend Ardbeg. But
Ardbeg, which one? Ergodile?
No, that wasn't the one.
The Ardbeg 10 is good.
Yeah, the Ardbeg 10 is really good.
Yeah, I like that one. I like the Ergodile. Very, very, those are great. And they're not super expensive.
Yeah, they're like $60-$70.
I will say, if you can find this, I've never seen this before till the other day. It's Penelope bourbon, straight from Kentucky.
I don't drink bourbon. It's too
well.
warm.
Yeah, I'm saying this guy though. This guy, Penelope bourbon. If you can find this is about $65. This is a phenomenal whiskey, but it's a little bit strong. It's a little bit strong, so it might not be your thing. Okay. Next, that's the Anton Shutter. Hey, what's up, Helena? Thank you for raiding with the Camelot crew. All right, let's get back to this damn lawsuit. Too many distractions.
Oh, seriously.
Which are all my fault. When plaintiff informed Mr. Cardin that she no longer wanted to co-host You Are Here, she said it was because she no longer trusted her co-host and no longer wanted to be associated with him or You Are Here. She emphasized that her frustrations related only to her co-host and further added that she enjoyed worked with everyone else at the network. Working. Blaze then offered plaintiff an opportunity to continue working with Blaze as an independent contractor by developing another show for her to host, either alone or with a different co-host.
Really?
Oh, wow. This just fucks her claim right in the booty.
What the heck?
You can work on another show. She agreed and took some time off while they were discussing such other project. Plaintiff led Blaze to believe she planned to continue working with it as she continually communicated with Gaston Mooney, president of Blaze, about a potential podcast and its content. Filed herewith as Exhibit 2. As recently as June 9th, 2022, plaintiff indicated to Mr. Mooney via text she still wanted to collaborate with Blaze, and Blaze continued to pay plaintiff for the talent fee in full pursuant to the TSA, expecting a new podcast idea. Holy shit, she got paid for not working.
Wow.
And she's saying that she was terminated.
Wow. I don't understand.
I was wondering that when I went through it the first time, because it kind of seemed like the show ended, but both of them were still employed for a while.
This is very... Wow.
I mean, you got paid for it.
Why is she suing? Why is there a lawsuit here? I don't understand anything that's happening here.
How is she going to say I didn't get paid? I mean, because she goes through June. Blaze did not learn about plaintiff's allegations of alleged underlying sexual harassment associated with You Are Here from 2021, and that she did not intend to participate in a new show with Blaze until receiving a demand letter from plaintiff's attorney on August 12th, 2022. Presumably, she was being paid through this, right? Like, it's ambiguously worded.
I think her last check was on June 9th.
Yeah, could be. Maybe. I mean, if they thought she was still employed by August, she could have gotten a July check too.
It could be that her her IC agreement expired in June.
So here we go. Plaintiff and her co-host, Mr. Schaefer, and his wife were friends outside of work, had a falling out in their personal relationship when Mr. Schaefer and his wife did not like plaintiff's boyfriend, an event wholly unrelated to an outside of her co-hosting You Are Here in accordance with the TSA. Cardin declaration at paragraph 16. And then this, what the fuck is this? This is a unmixed thing. I wonder if this is a copy paste error.
Yeah, I don't know.
I don't know what that's supposed to be. It's blank. So there's something that they had.
Some sort of appendix that they were planning on. Oh,
Yeah.
I guess the declaration they were going to attach as an appendix, and they forgot to put in,
changed it. Yeah.
Or maybe they forgot to label what the appendix was.
Yeah. Very weird. I mean, it happens. Oh, here it is. They have an appendix here, Appendix 04.
Yeah, they just forgot to put it in about.
Yeah. Plaintiff is attempting to circumvent her independent contractor status and the TSA obligations to spew inaccuracies to generate publicity for herself. The court should dismiss this action and compel arbitration because plaintiff entered into a valid and binding arbitration agreement with Blaze, covers the disputes at issue in this case. Further, Blaze is entitled to its legal fees and costs incurred in defending this action because plaintiff received notice of, agreed to, and accepted to submit any claims arising out of the terms and conditions of the TSA to mandatory arbitration. If she loses, she better hope she loses fast.
Yeah, because she's going to be paying 2 attorneys.
Yeah, and that was clearly written in the agreement. That's an unambiguous language that if it's arbitrable, then she'll be footing the bill for bringing the case in court. So
it could be that she won't have, if she wins an arbitration, that she won't have to foot the bill for this part.
Right, that's possible.
Yeah. But I don't. It
could
like
also be that if she does
win
in arbitration, she'll still have to foot the bill for this part.
I want to see their response. I mean, look, we haven't seen her response to this, but I want to see their response. And this is really powerful. This is a powerful 12v6 motion.
Yeah, this action should be dismissed, and plaintiff should be compelled to arbitrate her claims against Blaze. The strong federal policy favoring arbitration requires this court to enforce the arbitration agreement, compel plaintiff to arbitrate. U.S. Supreme Court has repeatedly adopted a broad reading of the Federal Arbitration Agreement or Federal Arbitration Act in enforcing arbitration agreements. Arbitration agreement between the parties in this case meets the criteria for a valid arbitration agreement, and plaintiff's claims are directly within its scope. Whew. You know what we should do? We should have something here. We should have some lovely Field of Greens. That's what we should do, Joe. We should have fieldofgreens.com. Go to Field of Greens. Look, their lean weight loss. I got so many people who are interested in this lean weight loss, being like a guinea pig. As soon as I talk to them, I'll see what I can do. I would. And
I just want to say, if you're not into Field of Greens yet, okay, I'm just going to point this out to you. I have seen countless memes of Chunketta where the dude looks enormous, and look how svelte he looks today. Look how skinny he is. That is obviously purely due to Field of Greens. So I don't know what he's going to say now. There might be certain things he's obligated under contract to toss out here, but I'm just going to say that I've never tried Field of Greens, but the results here seem to speak for themselves. Very impressive. You look way skinnier than in any meme I've seen of you in the last the last 6 months. So.
One thing I will say, Field of Greens does not contract me to any specific thing at all. These ads are completely freeform and within my control, and if they ever hate them, they can just fire me. Which is how I like it. I don't like being compelled to say anything, but I will be asking them about lean weight loss. But let's talk about Field of Greens right now. Today, I'm going to drink the wild berry. That's what I've been pounding down lately. I like it a lot. It has antioxidants or whatever, and it's got some good old immunity boosting bullshit in it. But it's all just from the vegetables. It's not like they dump a bunch of chemicals in here. Fruits and vegetables. It's a serving of fruit, serving of vegetables every day, because if you're like me, you don't get enough fruits and vegetables in your life. The only fruits I eat are Camelot.
Wait, what?
It's delicious.
I've heard so much about this Vegas trip.
It's legitimately delicious drink that you can drink every day. You're not suffering through it. Believe me, I've had some of those. Fieldofgreens.com. Use promo code NOSE. It's not the cheapest thing in the world. Make sure you take advantage of any discounts and give it a shot. Give it a shot for your own health. It's a great, easy way to boost that. And I will be learning more about their weight loss thing. It's just, if I lose more weight, it's because I'm losing limbs. Because I've lost a considerable amount. As Joe politely mentioned, I am down about 20 pounds.
Nice.
From the Johnny Depp trial. So
wow. Well done, you.
And getting down more than that is not a great place to be for me. But that being said, let me read the rest of these YouTube chats and we'll shoot over to Rumble.
All right.
Cult of Personality says Nashville shooting's going to get memory hold ASAP. What shooting? I never even heard of Nashville. Richard Grubber says, wow, Nashville used a braced AR pistol. I'll chalk this up to sheer coincidence. Oh yeah, what is Nashville like a special land that people are talking about? Is it a D&D game? Joe, I've never heard of this.
There was a singer who lived in Nashville, I think, or at least one.
I've never even heard of it. Is it next to Australia?
I think you're thinking of Korea.
Oh, okay. Ovid says big day for women breaking that glass ceiling, ladies. Came close at YouTube headquarters, but now you finally got it done. All it took was a couple shots of testosterone and equity is possible. Oh my God. Mario Carter 13. I disavow that statement, YouTube. Mario Carter 13. Would you say the court was very provolone? Yes. Yes. Avocado Cookie. Dim Fool talks a big game about free speech, then self-censors like the cumin cuckaroo he is. Don't believe the lies. He pulled that stream himself.
Cumin?
It's cumin. It's COO. Oh. It's not the spice, cumin. It's cumin cuckaroo.
All right.
I don't know what that is. But he pulled the stream himself. So yeah, I'm hearing different things, and I'm only hearing parts of them because I'm doing a show. But Tim Pool's show went down in the middle of the show. Oh. And some people are saying he pulled it. Other people are saying it got pulled by YouTube. No idea.
What was he covering? He was covering this?
I don't watch.
He was
Tim
covering.
Pool.
He was covering that Australian city thing.
Yeah, was Tim Pool covering Nashville? I have no idea. The Ava Blink. Hey Nick, can I get a prayer for my mother? Not really a religious family, but she is 2-tour Iraq vet and has PTSD causing her to want to find a way out. Had to put her in a mental hospital today. Been on and off for 6 years. Dude, yes, I will happily pray for your mother. I was going to do a toast. We'll pray for your mother. I will. I assume Joe will too, but yes, may God intervene in her troubles, in her stresses, in her mental health, bring her healing, bring her peace, and bring her to a zest and a love for life that transcends any depression.
Amen.
Cult of personality. Are y'all more or less shocked that it was a female to male T that committed this act rather than a male to female? Also, Joe, what does oy vey mean?
I don't know if there's a definition for oy vey.
It's just like, oh my, right? Like,
yeah, it's like, oh my.
Yeah. As for I wasn't particularly surprised about anything. The thing with mass shootings is there isn't a formula to them. That's the problem. Everybody wants to say, oh, well, if we just do this, we'll prevent X. It's like, but they're all different. They have different motivations, and these types of shootings are exceedingly rare. The mass shootings that are pretty common involve gangs.
Are we left YouTube land?
Not quite.
It feels like we're
not quite there. Avellone, my Bacta bourbon came in today. I'm super happy. Nice. Hayden 75. Also, I'm watching on Rumble. Just can't rant over there. So came here just to support and send a message. Everyone go to Rumble. Thank you. We're about to move over there. Corrections gear. Do you think Jane Fonda is culpable for saying Christians should be murdered on The View after the Tranbo shooting today? I mean, no, I don't think she's culpable. I think she's an idiot.
Those are two different things.
Yeah, and I don't know what she'd be culpable for. I guess if you're saying if a Christian gets shot in response to that, no, I don't think she's actually engaged in incitement under the legal definition. Unix EDU says, Joe is an AI, not real. Don't fall for it. Look at how it moves. True. Holocaust. Yissel, what do you call gay Semites? Fruit Jews.
That's kind of weak.
Yeah. He should have just wrote juice.
Yeah.
The word juice.
Yeah.
A tip for you, sir. Asia Fraser says, asking your base to Canada attention whores alone is hate. To maple. There's a maple leaf. Oh, leave attention whores alone is hate. Asking your base to leave attention whores alone is hate. Yes. Yes, that's what the article was about me. Revenge of the Netherrealm says, Camelot Raid. Thank you, Mr. Miracle Media. Nick, what are you in? What area are you in? Favorite bourbon? I'm in Minnesota, central Minnesota. My favorite bourbon is probably Joseph Magnus Cigar Malt. Kick Jack says, Nick, are you going to the private range event with Camelot in April? When is it? I have something you and Lady Rackets to do while in the area. I don't think I can. I really want to, but if I'm right on the date, there's like no way. Crass Cat says, I just watched my good friend pass today due to cancer. My heart is heavy right now. Can we raise a glass to DJ? He fought hard. Of course. You got any beverages tonight, Joe, or no?
My head is like pounding already. I'm like fighting a head cold, so I'm gonna pass on the alcohol tonight.
No pressure, of course.
Yeah.
I was just asking if you were because I was gonna wait for you, but now I'll just do a toast.
Appreciate it.
To DJ. A good man, presumably, a good man passing from a horrific illness, an ailment that looms over all of us, the unfightable dragon in many cases. May his passing bring peace to his body, calm to his spirit, and relief to his family as they remember the person he was and not get caught up in the sickness that overtook him. Cheers.
Salute.
And with that, we're going straight to Rumble. So I'll see you guys in 20 seconds. The link to Rumble is in the description. Thank you all for watching on YouTube. As always, please continue following us over on Rumble. And if you're not subscribed over on Rumble, you got to get on it. You got to get that subscription button.
No
also,
choice.
If you are a YouTube viewer, make sure you check out my good friend.
Good Logic.
This way. Good Logic on YouTube and on Rumble as well. And most importantly, goodlogic.locals.com. We love you guys. We'll see you in 20 seconds. Peace. Peace.
For the thousands in attendance and the millions watching around the world, ladies and gentlemen,